SJC-11314, Commonwealth versus Fortunato.
All right, let's proceed. Good morning.
Good morning, Your Honors. If it may please the Court, I am Assistant District Attorney Warren Lee from Middlesex on behalf of the Commonwealth. This Court, in announcing the new rule in Rosario, stated, and I quote, "We adopt for the future, with respect to police questioning of an arrested person," end quote, the 6-hour safe harbor provision. And here the motion judge erred in suppressing statements that were spontaneous, unsolicited, involuntary under Rosario, because Rosario simply does not apply where there's no police questioning. And here, it was the defendant. Your Honor, because in addition to the fact that it's explicitly stated is with respect to police questioning, it does not pertain to all statements here, because the prevailing purposes of the Rosario rule, and it states, is to prevent unlawful detention and to eliminate the opportunity and incentive for application of improper police pressure. Rosario is concerned with police conduct. And in announcing the bright line rule, it is concerned with and addresses when and under what circumstances the police may question an arrestee.
Mr. Lee, are you saying that this was not a custodial interrogation and therefore Rosario does not apply?
Yes, Your Honor. He was definitely in custody, but he was not interrogated. The defendant was the one who initiated the interaction. Defendant was the one 6 hours, 20 minutes after the arrest.
Will you focus on the 20 minutes? If it was, say, 5.5 hours, would you have the same position?
Your Honor.
No, it was within the 6 hours?
Yes, Your Honor. It does not bar statements that are made that are otherwise voluntary within the 6-hour rule, in the 6-hour period.
Did the police ask absolutely no questions?
No, Your Honor. According to the motion to suppress in the hearing, the Detective Saunders was summoned to the jail cell. There, he went downstairs and made contact with the defendant, and the defendant himself asked him a couple of hypothetical questions.
Wait a minute. Didn't the police ask him what his name was?
No, Your Honor, not in the cell, because he already knew who he was. He's the one who arrested him and booked him, and he did attempt to question him when he was arrested or at the time he was arrested, but the defendant refused or declined to be interviewed.
No. Couldn't this whole problem have been avoided if the police officer, we have to assume Rosario's been around for 17, 18 years. Police officers are familiar with the 6-hour safe harbor rule. It was more than 6 hours when Mr. Fortunato wanted to speak with a police officer. Police officer could have, before talking with him, simply said, "Can't talk with you unless you sign a waiver," because Rosario specifically provides that a waiver would allow for the conversation. The whole thing could have been avoided if the police officer had simply handed him a waiver form and said, "Sign this and then we can talk."
Your Honor, I believe a waiver at that point, well, reading or informing the defendant of his Rosario rights at that time was not required because there was no questioning. And here,
they didn't know what he wanted him to talk with him about, right?
Yes,
they didn't
Your
know
Honor,
in
but
advance. They just knew that it was Mr. Fortunato who had made the request to speak with them. But they didn't know what he wanted to speak about.
Your Honor, I would submit that the officer was not required to say, well, before you say a word, I'm going to reread you your Miranda rights.
The question is whether or not statements made outside of the 6-hour safe harbor period are going to be admissible after Rosario.
Well, Your Honor, the Rosario rule states that after 6 hours, you may not question a defendant unless you obtain a valid waiver. He wasn't intending on questioning him, so there was no reason for him to inform him of his rights and obtain that waiver when there was no questioning. Again, the police was not required to say, well, before you say anything, I'm going to reread your Miranda rights, and in addition, I'm going to tell you about these prompt arraignment rights.
But he had never been warned about the right to prompt arraignment.
No, he wasn't, Your Honor. At booking,
he'd never been read anything or warned of this in any way.
Well, if he had been read his Rosario rights alongside Miranda at booking, I don't think we wouldn't avoid the same situation, because he invoked his his rights under Miranda, he would have invariably invoked his rights under Rosario. He would have waived his rights. But by the defendant's own argument, absent waiver, all statements are excluded.
Well, I mean, I think the defendant would have a tougher time if this were a situation where somebody blurted out a statement at 6 hours and 20 minutes. But he summons the officer, as Justice Lang said. What would have been difficult just to get the waiver at that time? And don't you think that Rosario, yes, it talks about interrogation, but part of it, it seems to me, is the idea that the pressure of being held for a long period of time is going to induce somebody to do something against his will. That is, speak. So I'm not sure that Rosario necessarily should be read to be confined strictly to straight interrogation.
Well, Your Honor, if the statements were a product of prolonged detention, whether they were prompted by police or spontaneous or unsolicited, well, they would be inadmissible on other grounds, perhaps on constitutional grounds, and whether those statements were intelligently made or they're born of free will. In addition, those statements perhaps would be inadmissible on Rule 7 prompt arraignment grounds, not necessarily Rosario. Was there an unreasonable delay? Was there police misconduct here that bore a rational relationship with the statement and the police conduct and the delay? So,
You know, I understand you to say that in this case, because the police did not ask questions, Rosario does not apply. But let me ask you just hypothetically, if the police had asked questions, would you agree that there is an absolute 6-hour rule?
correct, Your Honor. It applies to
Bright
police.
line.
Yes, it's a bright line rule where if you question someone after 6 hours, you must obtain a waiver.
So if we view this as a situation where whether questions were asked by the police or statements were volunteered, if we said that it really doesn't matter and we just focused in on the timeline, the 6-hour period, we might reach a different conclusion, right?
Well, Your Honor, I think if we take the defendant's own argument and logic at face value, we reach kind of an untenable result. Spontaneous utterances made within the 6-hour period after arrest are admissible. Spontaneous statements made after arraignment, it's admissible. There's really no good reason why spontaneous utterances or admissions made after the 6-hour period and prior to arraignment is inadmissible or suppressed.
Well, there's a difference between the two. I mean, it seems to me that what Rosario was getting at is if statements are otherwise admissible, but they're made outside the 6-hour period, they're going to be rendered inadmissible by virtue of not being within the 6-hour safe harbor rule. Because that is a sort of an arbitrary 6-hour period that the court decided in Rosario is simply going to sort of balance out the different considerations that were always being argued about, which, you know, sometimes it works for the defendant, sometimes it works for the Commonwealth. But these are all relating to statements that would otherwise be admissible.
Yes, Your Honor, but I believe this court made it clear in Rosario that the defendant may waive his rights at any time.
At any time?
Yes, and after the 6-hour period. And I believe that suggests, there's nothing in Rosario to suggest that a period of detention of 6 hours or longer is in and of itself inherently coercive.
No, but it's also true that, you know, if an arrest had been made at 10 o'clock and the courts were open for the next 6 hours and the defendant had exercised his Miranda rights and said, I'm not going to be talking, that there could be circumstances where that would be considered to be an unreasonable delay in getting him to court.
If he had not been arraigned that same day?
Yes.
Yes, that is correct, Your Honor.
Right,
There has to
and
be-
we avoid those questions with Rosario by saying, no, the police still have 6 hours within which to hold him,
Yes, Your Honor.
even though it might be unreasonable in other circumstances.
Well, yes, Your Honor. I think those are the cases that are pre-Rosario. Is that
No, I'm just saying that you know, Rosario is basically striking a balance and saying, we give the police 6 hours within which if they want to question or if there are going to be statements made, those are okay if they're otherwise admissible, even though we could look at that and say it's an unreasonable delay in getting him arraigned. And you know, there are going to be times with that, so that's in favor of the Commonwealth in that situation.
Yes, Your Honor.
Here, the man was not arrested until 4 o'clock, 4:10 in the afternoon. Courts were closed.
Yes.
So, you know,
And the statements were made at 10:20. There's no possible way to get him into court and be arraigned at that time.
no, but if it had been made 20 minutes earlier, no problem.
No problem at all.
Right.
And there shouldn't be a problem after the 6-hour period under the
Rosario
same
suggests that
circumstances.
there is.
Well, Your Honor, absent any police misconduct,
I don't think Rosario is talking about police misconduct being factored into this.
Well, Your Honor, I believe Rosario addresses police misconduct because that's what the rule is designed to prevent. And I believe the cases that have come down since Rosario address that as well. And Morganti and Tran in particular are concerned primarily with propriety of police conduct, where in Morganti, it specifically spoke of the dangers that triggered the need for the rule, namely that police officers would delay a defendant's arraignment in order to procure a confession from an unrepresented defendant. And here, the defendant was arrested in California. There's no possible way to be arraigned in Massachusetts
Fell into
within
an
6
exception
hours.
that Rosario contemplated.
Exactly, Your Honor. But nonetheless, the court took pains to explain why the police conduct did not violate the spirit of the Rosario rule. Likewise, in Tran, there was no valid waiver, but nonetheless, the opinion hinges on propriety of police conduct. In that case, the defendant was extradited from China. He was arrested in Logan 11 o'clock at night after a 12-hour flight. The reason why he wasn't questioned within the 6-hour period was because the police gave him an opportunity to rest so that his statements will be voluntary. And in that...
But you have said, I think, that Fortunato did not, or that Saunders, Officer Saunders, did not ask Fortunato any questions at 20 minutes after 10.
No, Your Honor. The defendant asked the officer questions, and he just answered them.
Okay.
Let me ask you this. In Rosario, we sort of followed Pennsylvania. Now, Pennsylvania has abandoned this rule largely.
Yes, Your Honor.
Is there any state that you know of that maintains a sort of a 6-hour bright line rule?
No, Your Honor. I believe it's the only other jurisdiction that has the 6-hour rule in place is the federal system.
All right.
And the federal system derived from the case law with regard to involuntariness and the concern about when a statement becomes involuntary because of the prolongation of interrogation and of detention, correct?
Yes, Your Honor. But nonetheless, McNabb-Mallory was not a constitutionally based rule. It was a federal court-based rule in which it stated that it bars the admission of otherwise voluntary statements on grounds of unreasonable delay in arraignment.
Right.
And Rosario is not a constitutional rule either.
It's not. It's a state common law rule as codified in Rule 7.
But you say that, but isn't it in part derived to provide a bright line to avoid the difficulty of ascertaining when
Well, Your Honor, I think the
detention has grown too long to be and therefore affected the voluntariness of the statements?
I think the bright line aspect of it refers to the 6 hours itself, what the police can do during those 6 hours and what they may or may not do after the 6 hours. The bright line aspect does not refer to suppressing any and all statements, no matter how they came to be. If there are no further questions, Your Honor, the Commonwealth would like to rest on its brief.
Thank you.
May it please the Court. I'm John Fennell, and I represent Jason Fortunato. While Fortunato was in custody, the police never informed him of his right to a prompt arraignment. And the right to a prompt arraignment is about more than preventing the defendant from making a statement due to improper police pressure. Prompt arraignment also ensures that the defendant be provided with a recitation of the charges against him by a member of the judiciary.
Can I ask you this? If the officer summoned to come to speak to the defendant had started the conversation by saying, would you like to sign a waiver, would that have been okay?
If he started the conversation...
By asking a question, would you like to sign a waiver?
He can ask that question. What Rosario is a mechanism to enforce bringing the defendant before the judiciary promptly. These statements, he could be asked, would you like to sign a waiver? Here's what the rights are. You can sign it. Chief Justice Liakos was specifically concerned in his concurrence in Rosario that this ability to sign a waiver after the 6-hour period really gutted the Rosario rule.
I know he was concerned about that, but we have fairly consistently said that the waiver is valid even if it's executed after the 6 hours, so long it was knowing and voluntary.
Yes, Your Honor, and that's something that was available to the Commonwealth here. I merely want to point out that even though Rosario looks like this strong, robust rule in this setting, at the time Rosario was decided, the Chief Justice was concerned that it was weaker and that the ability to obtain a waiver after the 6 hours was gutting it.
Okay, if you can play this out for me. He was interviewed, what, about 4 hours into the 6 hours of the actual interview?
I don't recall that it was sometime after booking.
Okay, but it was certainly within the 6 hours. Okay,
yes.
so let us assume that it had gone a little bit differently. Let us assume that they had said to him at that time, you have a right to a prompt arraignment. Do you wish to waive your right to a prompt arraignment? He says no. Okay, he said, I don't want to waive that right. Okay, it's 8 o'clock at night. There's nothing they can do until 9 o'clock the next morning. And so he's refused a waiver, and when he's being taken from the lockup to go to court the next morning, he says, I killed her, without any questioning. In your view, would that statement be excluded?
Under Rosario, yes, and under our view, yes.
And why would we do that?
Why would you do that? Because it doesn't fall under any of the exceptional circumstances provided for by Rosario. Mr. Fortunato doesn't know where he's going. He doesn't know where he's being taken. The rule is to ensure prompt arraignment, which is also to facilitate.
But of course, there's nothing they can do. It's after court's closed, so there's no claim of wrongdoing here. But the question is, why would we, as a common law, essentially say, in that particular circumstance, in the absence of any police misconduct, in the absence of any police questioning, that we would bar evidence that would be overwhelmingly incriminatory, overwhelmingly important?
There are two reasons, Your Honor. The first reason is that this court already considered the issue of how to adjust the 6-hour rule depending on whether or not courts are opened or closed. And this court already made the policy decision that this rule will exist independent of when courts are open or closed. So that decision has already been made. And the second reason is Rosario is a prophylactic rule to prevent police misconduct.
Right. Okay, and where's the misconduct in my example?
It's to prevent. It didn't happen in your example, but the point is that it's to expedite bringing the defendant to court where these important rights, like facilitating the right to counsel and ensuring that the detention is not unlawful, can be upheld.
But doesn't that go to Mr. Lee's point? I mean, the misconduct that you're describing would be the attempt to interrogate somebody after the 6 hours. And that's the misconduct that was being protected against, is the idea of wearing somebody out. In the absence of any, not to mention interrogation, any questioning, how can there be police misconduct where there is nothing the police, in the example here, there's nothing they could have done to get him to court before 9 a.m. the next morning?
Well, Your Honor, this court already made this policy decision to adopt a rule to prevent police misconduct. In your example, police misconduct did not take place, and that's a good thing. And the rule doesn't need to wait for police misconduct to occur before requiring suppression. Suppression here is the only available mechanism to ensure that these rights are upheld.
Okay, the issue, though, is not whether the rule should be upheld. The issue is what the rule means. And what Mr. Lee is arguing is to say the rule only makes sense in the context of police questioning. Otherwise, the rule really is foolishly overbroad, and we've never applied it that way. So why should we start now?
Well, in the cases so far, there's been no distinction between solicited and unsolicited.
Do we have any case in which it was unsolicited?
I know Your Honor wrote the opinion in Morgenta, and I know there
There was
was
definitely questioning.
and then there was also the statement that he made that was picked up on the video, so that would have been an unsolicited statement. And no distinction in the Rosario analysis in Morgenta was made between solicited and unsolicited statements, and the prior cases say plenty of times any statement or a statement without any mention of this distinction between solicited and unsolicited statements.
Yeah, but I mean, Morganti, the police came down specifically for the purpose of questioning him, and he was interviewed for quite a long time. How does that help you?
Well, I'm just referring to the statement that he made that was picked up on the video, where he was on the phone, and in Morganti, and he said to his son over the phone that your father
okay.
did a bad, so that was an unsolicited.
Okay, but
And no distinction.
is there any case in which it mattered that we have said that anybody has even argued or we've ever said that if it's not obtained by questioning, if it's obtained spontaneously, if it's volunteer, in this case, the questioning was done by the defendant, not by that we would invoke the Rosario rule?
There's no case that I have found where this court has made a distinction between solicited and unsolicited for the purpose of suppressing under Rosario. That's true. But the important thing here about the first question Fortunato asked when the police officer came to him was about the charges. What are the charges that I'm facing? Are they final? And that's being read the charges by a member of the judiciary is one of the rights that the right to prompt arraignment is designed to bring about. Fortunato is specifically asking about something that Rosario was written to ensure that he would learn from a member of the judiciary.
You know, maybe you could clarify for me. I was struck by one of the questions that Justice Gantz asked you. So if a person is arrested during the day and courts are open, they have to be brought in for an arraignment as soon as possible.
Yes.
If they're arrested at the end of the day and court isn't open again until the next morning, they're going to be in custody for maybe 12 hours, maybe longer.
Yes, Your Honor.
And so I guess I'm asking if we might have two different sets of rules, one for those people who get arrested during court hours and they're going to get in, and those who get arrested at the end of the day, they're going to be held for a longer period of time. Does Rosario apply to both situations?
Rosario applies regardless of whether the courts are open or closed. The court in Rosario considered that situation and decided that the blanket bright line rule of 6 hours would apply regardless of whether courts are open or closed. So that proposition was for two different sets of rules, and a tolling for when courts are closed was specifically considered and rejected in Rosario.
So your position that, taking the Chief's question, the person's arrested at 5 o'clock, there could be no misconduct to deliver him at 9 a.m. in the morning. That if a statement is volunteered at 7 a.m. as the person is being brought to court, that has to be excluded, even though there is no misconduct, no possibility of misconduct by the Commonwealth.
Yes, he hasn't been brought to court yet, Your Honor. The right has not been perfected at that point.
Okay, so you say basically you're saying that misconduct is irrelevant, even though there's no misconduct, we're still going to exclude it.
Yes, it's designed to prevent misconduct and effectuate the perfection of these rights.
Okay. So let me give you another example. Person actually affirms his rights to it. Say, yes, I do invoke my rights. I do want to go to court as soon as I can. Okay, we'll get you to court as soon as we can. And then he still makes a statement. And in fact, let's assume he is brought to court as soon as they possibly can. 8 o'clock, you're first up, Mr. Fortunato. We're going to take you to court right away. 9 o'clock, you're going to be arraigned at the earliest possible moment. And then he blurts out a different set of facts. I killed her. Still excluded.
While he's being arraigned at this point?
No, this is before he's being arraigned, while he's being brought to court.
And this is overheard by someone who is...
By somebody bringing him from the lockup, yeah.
Someone bringing him from the lockup? Until... I would make a distinction between the people who are holding him and people who are not. But if he's hasn't had this right perfected, this right to a prompt arraignment, then I would say the statement needs to be excluded.
So if he's arraigned, no statement has been made, he is arraigned, and then at 10 or 11 o'clock in the morning, the police, and he's held on bail, the police drive him over to the House of Correction to be held because he hasn't posted bail. And en route, no questions asked, he says, "I killed her." Is that statement admissible?
Well, he's been provided with an attorney at arraignment, and then this would be a statement. If he makes a statement then after he's been provided counsel, then I don't recall exactly the law on that once he's been provided, but I believe that's right, that if he would then blurt out after been provided an attorney, then that would be admissible. The right's been perfected. He's been provided with his right to an attorney. He's been able to meet with counsel. The rights that prompt arraignment was designed to bring about have been perfected, and that statement, nothing in Rosario would exclude that. That's right. The changes in the Pennsylvania rule are irrelevant to Rosario for three reasons. First of all, the rule that the cases criticize was actually a rule from before the rule that Rosario looked at to change. Pennsylvania had two versions of a 6-hour rule. The first version required suppression of any statement if arraignment did not occur within 6 hours. When in the Perez decision, when they're quoting cases where there were problems with the 6-hour rule, those are the cases they're talking about. Then the second version of the 6-hour rule in Pennsylvania that the Rosario court looked at, that rule did not have the waiver requirement that Massachusetts has. Massachusetts is the version of the rule Massachusetts adopted in Rosario was more flexible than the per se rule in Pennsylvania. In Massachusetts, there was waiver. In Pennsylvania, there was not. It was per se suppression if the statement was made after 6 hours in the second version of the Pennsylvania rule. And finally, in the decision where they reject the 6-hour rule and go back to a totality of the circumstances rule in Pennsylvania, in footnote 5, they refer to Massachusetts as a jurisdiction which has abandoned the McNabb-Mallory rule, which is just false. So the Pennsylvania case has all kinds of shoddy reasoning. When Justice Souter in the Corley decision upheld the McNabb-Mallory rule in 2009, he quoted Justice Frankfurter. And there Justice Frankfurter's observation was that the history of liberty has largely been the history of procedural rights. In a case where the defendant was not told of his right to a prompt arraignment, and his statement occurred more than 6 hours after his arrest, his statement should be suppressed, regardless of whether it was solicited or unsolicited. Thank you.
Thank you, sir.